I'm Carmen Ciparick, the chair of the Board of Trustees of the Historical Society of the New York Courts, and I welcome you to what promises to be a most interesting, exciting, informative, and timely program. First, I would like to acknowledge our gracious host, the New York City Bar. Thank you for once again opening your home to the Historical Society, and I urge those of you who are not members of the Historical Society to join us so that you can be part of our continuing court history. As you know, we, as voters in New York State, will be faced with a ballot proposition in the fall as to whether or not the convening of a constitutional convention for the purpose of amending our state constitution is in order. Tonight, you will hear about the history of the Constitutional Convention process in New York and what a convention at this time in our state history could look like. But first, I would like to introduce our first speaker, our fabulous Chief Judge, Janet DiFiore. Judge DiFiore has been Chief Judge for 15 months. Yeah, and counting. And in this short time, she has achieved so many wonderful and exciting reforms in our courts, including her Excellence Initiative, which invites all stakeholders and members of the public to comment on current court processes to determine what's working well and what areas can use improvement. She has surveyed the entire state and is implementing reforms throughout the state. Her dedication to the courts and her energy are boundless. And we at the Historical Society are very fortunate to have her as our leader. Just a brief biography, I'm sure you know it, but I'd like to repeat it. Judge DiFiore hails from Westchester. We won't hold that against her. She hails from Westchester. She attended college at C.W. Post in Long Island and law school at St. John's, my alma mater. She began her career at the Westchester County District Attorney's Office, did a stint in private practice, returned to the Westchester DA's office as chief of the office's Narcotics Bureau, and in 1998 was elected to the county court, and in 2002 to the Supreme Court in Westchester County, eventually becoming the supervising judge of the criminal courts of the 9th Judicial District. In 2005, she was elected to the position of Westchester County District Attorney, where she served for 10 years until that glorious day in January of last year when our very enlightened governor, recognizing Judge DiFiore's abilities, nominated her as Chief Judge of the State of New York and Chief Judge of the Court of Appeals. What a happy day for all of us who labor in the judicial and legal vineyards. And for me personally, what a treat. We had become friends as a result of co-chairing the Chief Judge's Justice Task Force. I had the occasion to personally observe her at work, bringing together diverse views in the criminal justice arena with the aim of eradicating the scourge of wrongful convictions. And just last week, we saw the fruition of some of her hard work, the enactment by the legislature of a criminal justice reform package which she championed. So, tonight, we will hear Judge DiFiore speak on another topic which touches all of us in the profession. So thank you, Judge, for joining us this evening for this important discussion and for your continuing support of the work of the Historical Society of the New York Courts. It gives me enormous pleasure to introduce to you my friend, our Chief Judge, Janet DiFiore.
Good evening, everyone. What a terrific crowd. Thank you all for being here. Before we begin our program, I ask you all for a moment of silence in memory of our dear friend and colleague Sheila Abdus Salam, who passed away last week. Thank you. And while, of course, we will appropriately mourn our colleague and friend, the work of the court and the justice system must continue to move forward. And toward that end, I want to take the opportunity of thanking the Historical Society's president, Al Rosenblatt, the chair of the board, Carmen Ciparick, the members of the Historical Society, Marilyn Marcus, I'm looking for you, and her staff, for all the wonderful work that you do in carrying out the mission of the Historical Society, which is to preserve and celebrate the rich legal history of the state of New York. And tonight, the Historical Society has certainly outdone itself by organizing this very timely and valuable program, anticipating the historic event that lies before us in 7 short months. On Election Day, November 7th, 2017, we'll have the opportunity to determine whether to convene a constitutional convention. And to help us better understand the value of that opportunity, we have 2 excellent panels who have been assembled for us this evening, panels made up of scholars, public officials, bar leaders who have devoted extensive study and thought to the successes and, yes, the failures of some of our conventions, and to the potential opportunities and challenges that a constitutional convention will present for the New York State judiciary, and of course, by extension, for all of the people across this state who come to our courthouses seeking our justice services. So setting the stage for this evening's panel is Dr. Peter Galie, who will be introduced more fully in a moment or two. He will take us through the history of our founding charter, and then we'll hear from our panelists about the 1967 convention, as well as about potential reforms to the Judiciary Act. And I know that this will be, for all of us, a very interesting and informative program this evening. And before we do get started with the program, if you will all allow me a brief moment of professional privilege, I would like to take the opportunity to thank a few people who are present here. Last year, I convened a task force on the New York State Constitutional Convention, and I invited, and they graciously accepted, judges and lawyers and academics to serve on that commission. And the purpose of the commission is to report and recommend to leaders in the judiciary and members of the judiciary about what's to come and what the possibilities are. And so Alan Shankman, who I know is here, serves as co-chair of our commission. Dennis Glazer serves with Alan as co-chair. Hank Greenberg serves not only on our commission, but chairs the State Bar's Committee. And Carrie Dunn, I know you're in the audience here, Carrie, as well as, who am I leaving out? Mark Blaustein, just a encyclopedic knowledge about the comings and that are about to come forward. So I'm happy to have this opportunity to publicly thank them and commend them for their service to the courts and in assisting us to be prepared for the challenges that we hopefully face starting on November 7th. So without any further ado, I believe I'm turning the program over to Hank Greenberg, and I look forward to enjoying the evening with all of you as well. Thank you.
Good evening. I just want to echo what the Chief Judge and Judge Ciparick, their observation about the size of the crowd we're seeing tonight. This is the second time in about the space of a month I've had the privilege to be with my friends at the City Bar, and it is an enormous tribute to this great bar association and this great hall that you have come out in such numbers on 2 consecutive evenings. It says a lot about not just this membership, but the level of curiosity about constitutional conventions. And then there's that simple question that boggles the minds of so many people, which is, what is a constitutional convention? And this evening, we're going to begin to give some context and flavor by looking backwards in the beginning, and then towards the end of the program, looking forward about what potentially could happen at a convention. We begin at a fabulous spot because it's my privilege to introduce you to someone that, at least in New York constitutional circles, is a household name, but perhaps not to the broader profession or public. But for those of you who have had the privilege to encounter the writings of Professor Peter Gailey, he is without question, and has been for decades, the preeminent thinker, commentator, and writer on all things relating to the New York State Constitution and its history. He is the author of, undoubtedly, the leading works, published works about the state constitution. Ordered Liberty is the first and last word, at least in print today, about the New York State Constitution. His treatise, published by the Oxford University Press on the New York State Constitution, is likewise sort of the definitive treatise in print today, canvassing all 20 articles of this virtually unreadable document. And while the subject itself might not be perhaps the most exciting to some academics, Peter Gailey has been the keeper of the flame for years. You know, final observation I'll sort of make is, in the late 19th and early 20th century, New York was blessed because there was a gentleman by the name of Charles Lincoln who wrote a 5-volume treatise that really captured all that existed at that time in terms of our constitutional history, and a proud history it is. The state constitution predated the federal constitution by 10 years, and the father of the federal constitution, James Madison, often acknowledged the inspiration of the federal constitution started in New York. But we had Charles Lincoln in the 19th and 20th century, and for years was recognized, still is from time to time cited by the Court of Appeals. Well, today we have Peter Gailey, the Charles Lincoln of our time, and it is my privilege and pleasure to introduce Professor Peter Gailey.
All I can do is smile and blush. Thank you.
Who's going to do slides?
Members of the Historical Society of the Courts of New York, Chief Judge DiFiore, Judge Rosenbat, Marilyn Marcus, I hope I have that correct, officials of this organization, members of the bar, and guests. The Historical Society of New York, the sponsor of this event, has provided a fitting program for an organization whose mission is to preserve, protect, and promote the legal history of New York, including the proud heritage of its courts and the development of the rule of law. Our constitutional tradition has suffered neglect for too long, buried as it is under the massive attention given to our national document. The vote this November asks citizens to engage in civic action of the highest order by the exercise of one of the few remaining forms of popular sovereignty in this nation. Informing citizens of this vote and its significance is quintessentially the task for the Historical Society of the Courts and the Bar Associations of New York. For that, those of us who have labored in this vineyard for some years are deeply appreciative. It was 20 years ago today, well, maybe not today, when I stood here along with Hank DeLay, who's here tonight, Michael Cardoza, Shirley Eberly, the president of the Rochester League of Women Voters, and Professor Herskovits, to debate the question of whether we should hold a constitutional convention or not. I was in favor. I hope I'm more successful tonight. The subtitle of my talk, Back to the Future, aside from the clever paradox posed by the phrase, is there any other justification for this plagiarism? There is. It came to me after reading 2 letters that John Jay wrote to Governor Morse and Robert Livingston just before and after the 1777 Constitution was adopted. On April 17, 1777, Jay was called away to care for his dying mother. In his absence, some changes were made that aroused his ire. The first conferred on judges the power to appoint clerks of their respective courts. He described that measure as patronage and nepotism. The second required attorneys to be separately licensed in each court in which they would practice. He described the provision as, and I quote, "the most whimsical, crude, and undigested thing I've met with." Did it make any sense, he continued, to require attorneys seeking general license to obtain admission in the Supreme Court, 3 mayor's courts, 13 inferior courts, courts of common pleas, 14 sessions courts, and Lord knows how often or in how many courts of oyer and terminer and jail delivery? Does that sound familiar? Can we see in Jay's critique the shape of things to come as we struggle to bring order to the courts and to make them more user-friendly? If I have time, and I probably won't, I shall return to this topic. Let me now turn to this PowerPoint presentation, which gives you a kind of very fast view of what I consider the highlights and the significant parts of the constitutional tradition of New York. I hope I've emphasized the kind of things that will illuminate our current position, as well as the important and interesting historical data. And maybe someone will even ask me, what the hell is that picture doing as a start? The Constitution, I hope, is not, it is implied, in ruins. Conventions by the numbers. New York has had 9 constitutional conventions: 1777, 1801, 1821, 1846. Well, you can read them there, right up through 1967. The current gap between conventions, if you look at the numbers, is the longest in New York's history. New York has adopted 4 constitutions: 1777, 1821, 1846, and 1894. The current Constitution, adopted in 1894, was substantially revised in 38, but is not considered a new Constitution since it was not submitted as a document in toto to be approved or disapproved. All but one of the conventions have been unlimited, meaning that once they're called, all's fair. Nothing is off limits except those provisions of the federal Constitution which would limit what the delegates could do. We only had one limited convention in New York. It was called in 1801 to consider the reapportionment and the Council of Appointment. The current language, placed in there in 1846, seems to preclude a limited convention. This causes a sadness in my heart, because I'd like to see something like that available to New Yorkers. In any case, the provision says, shall there be a convention to revise the Constitution and amend the same, and under that old principle that the inclusion of one is the exclusion of another, apparently most have concluded that a limited convention is not within the purview of constitutional conventions being called in New York. Historic role of conventions. Conventions have played a central role in the constitutional history of New York. Most of the provisions, I'll emphasize this, most of the provisions in the Constitution that we point to with pride have been inserted by constitutional conventions. Nearly all the rights provision, I could say this twice and not be redundant, nearly all the rights provisions in the Constitution that we value, that are important to us, were the results of constitutional conventions, not legislative action. Conventions have also given us a Constitution that reflects and sustains our ideals. What have conventions done? Well, obviously, this starts with very elementary things. They've adopted basic structures of government. In 1777, we had this tripartite structure that we're all familiar with a bicameral legislature. But it's also important to notice that there was no hard and fast rule about what was separation of powers or not. The Council of Revision, which was a kind of a review body of what the legislature could do, was made up of the governor and members of the court. That clearly transcended traditional separation of powers lines. And we've always done that in New York. Nonetheless, there is this basic tripartite structure. In 1821, the convention lodged the veto and appointment power in the governor. In 1846, the convention established the Court of Appeals as the state's highest court. And, I might add, made all the courts of the state elective. an issue which we are still grappling with today. In 1894, the convention established the current department structure of the judiciary. This is a little sidebar here, but in the 1894 convention and the 1915 convention, we witnessed in New York the last hurrah of Protestant Republican New York. And there were attempts at that convention to preserve that New York. And it occasioned a great debate between Lewis Marshall, who was a delegate to the 1915 convention, and a very prominent German Jewish civil libertarian lawyer, and another famous New Yorker, Elihu Root, who exuded the Protestant ethic and the tradition of noblesse oblige, but who also felt that the increasing numbers of immigrants from Southern and Eastern Europe were not compatible with the rule of law tradition of the Anglo-Saxon mind. And that debate arose heatedly between Marshall and Elihu Root both outside the convention and inside the convention. And in a move to attempt to solidify or keep out these immigrants, a proposal was made that you couldn't vote unless you could read in English. And Marshall got up and thundered about that. If you want something like that, say, read in any language. And he then started to talk about the number of Yiddish publications read by tens and hundreds of thousands of Jews in New York, and the literacy rate that they had, independent of the English. So that convention for me was a kind of last hurrah for the attempt to hold back the borders or the walls that were crumbling in the face of a new New York. So Lewis Marshall is, and here's the picture of Elihu Root, whose picture also is in, I think, one of the rooms here at the New York Association, which Hank was kind enough to point out. What have conventions done? Well, they've added rights for defendants, for example, in the 1777 Constitution, had no formal Bill of Rights, but contained a number of rights provisions: jury trial, right to counsel, due process, the vote, religious liberty. The 1821 Convention created, for the first time in New York, a separate Bill of Rights, made it in Article 7. It added a right to grand jury, freedom from self-incrimination, habeas corpus, and a free speech clause. 1846, the convention prohibited excessive bails and fines. 1938 convention added a prohibition against unreasonable search and seizures. By the way, the great debate that took place, it's just a wonderful read to see the forces who were not so much opposed to adding a separate search and seizure clause. The great debate took place over whether an exclusionary rule should be added to the Constitution. And Senator Dunnigan and Dewey, outside the convention, they introduced his speeches. There was a tremendous and lengthy debate, I think one of the great debates in the annals of New York constitutional history, over this fundamental civil liberties question, before it became an issue of some significant importance for the Warren Court, although it had been raised at the federal level. Here, just as kind of a sidebar, these are cartoons that are in the archives, and they are by Jerry Costello, who did a lot of these cartoons for the New York Knickerbocker. Long gone, right? I don't know when it disappeared. I don't think it's any longer in extant. But here's one giving some idea of what the one cartoonist thought about this Constitutional Convention in 38, what it ought to do. What the people expect: a lot of this, the job of revising our state constitution, and little of this. This is an old canard in the newspapers, politics. And the second one here, he wants it short and plain. State Constitutional Convention cookery. Just give me something I can digest. And this kind of anticipates a famous remark that Al Smith made at the 38 convention, when he said, we ought to have a constitution, this is typical Al Smith, we ought to have a constitution you can fit in the back pocket. You know, that was it, simplified. And this is, of course, in anticipation of that view. And there he is. His last hurrah, speaking of last hurrahs, Al Smith, favors whittling Constitution to the pocket side of the ears with a cigar. It looks like it's about 6 or 7 inches long. He's got his vest, his brown derby, and his forward-looking face, and he's talking there in this article about the importance of getting rid of all the stuff in the Constitution that simply doesn't belong there. What have conventions done? Well, they provided the ground rules for state and local fiscal policies. There was a referendum requirement for state debt added by the 1846 Constitution. This is a very important bone of contention that any convention that does meet in the future has to address this question: does this debt limitation make sense, this referendum? Because about 94% of the state's debt is not referendum-based debt. I mean, we've found effective ways to get around it. Maybe it doesn't belong there, but the 1846 Constitution put it in. There's a ban on gifts of state credit, added again by the 1846 Constitutional Convention. There's a provision that prohibits state and local guarantees of public authority indebtedness, added by the 1938 Convention. That's still an issue of some difficulty. What have conventions done? They've been socially progressive. Environmental protections, such as the Forever Wild, the Conservation Bill of Rights, that's largely aspirational, but nonetheless without some significance. Some people suggest that if we did have a constitutional convention, that Conservation Bill of Rights, the right to clean air and water, not be aspirational because it's discretionary at the legislator's will what it will do about that, that we could tighten that up and say, look, we want to mandate it the way we mandate something like education or the Forever Wild provision. There's a right, of course, to aid and care of needy, put in by the 1938 Convention, and also the authorization of low-income housing. Third, what have conventions done? We've given the citizens the opportunity to revise state constitutions without government approval. Every 20 years, the people get to decide whether to hold a constitutional convention. Can you imagine the legislature giving this power to the citizens? I can't. It's a remarkable example of prescience, I think, because there are times when, for various reasons, the governmental apparatus stops functioning, loses the trust of the public, becomes constipated and difficult, and things need to be done. And I think the people who put this in 1846 realized that, and it was precisely the basis for this every 20 years provision. It has its problems because there's a rhythm to every 20 years that may not coincide with the rhythms of problems and reform movements. Nonetheless, it was one of the most valuable things, I think, that the 1846 Constitutional Convention did. Unsuccessful constitutional conventions. The work of 6 of the 9 conventions was largely approved by the voters. 3 conventions, 1867, 1915, and 1967, did not have their work approved by the voters. However, the 1867 convention submitted a separate judiciary article approved in 1869, and much of the 1867-68 convention's work was included in the recommendations of one of the, I don't know whether it's the first New Jersey, New York vie for this, one of the early uses of a constitutional commission to provide recommendations to change things, those recommendations were made to the legislature, and they were based on much of the work of this convention. 1915 convention's work was adopted by later amendments in the 20s. The short ballot, the executive budget, the executive reorganization, all of these were the work of the 15 convention, later adopted by amendments in the 20s. The 1967 convention, of which we will have a panel here, so I won't say much about it, the Conservation Bill of Rights, state financing of the court system, redistricting commission, found their way into the state commission, the Constitution, in one form or another over the next 25 years or so. The future of constitutional reform, decline or dormancy. The last state constitutional convention was held in 1967, a half century ago. In the last 30 years, the state has adopted 26 amendments, the lowest number for any 30-year period in the last century. From 1946 to 1955, there were 36 amendments adopted. From 1956 to 1965, 36 amendments were adopted. And more importantly, the amendments adopted between 87 and 2017 did not address any of the fundamental problems facing the state. They dealt with non-structural issues such as civil service additions, adjustments in the Adirondacks, exchanges of lands, those kinds of things. Important, of course, but not in any way involving the structural issues such as that we need to deal with. They had gambling provisions, exceptions to that, exclusion for debt limits of sewage facilities. Every time I think of that, I think that stinks. Finally, that's my quick review of the Constitutional Conventions. I want to just conclude with a note towards the judiciary article. If you take the judiciary article and the two articles, state and local finance, together, they constitute 30,000 words of the 50,000 document, raising very important questions about, are we going at this problem of the judiciary article in the Constitution and finances in the wrong way? Do we need to do that? Why do we do it? So take a look at this quick review. I took the words oath. Thank the Lord for computers. You can do this just by looking at the bottom of the page. In 1777, they barely talked about it. They didn't mention, only one court was even mentioned in 1777. There were 296 words. 1821, there were 913, not bad. 1846, that was the first Constitutional Convention to really give the judiciary some attention, 3,000. 1894, 4,000. But notice what happens. From 1894 to 1938, the size doubles. Then in 67, you have a retrenchment, if you will, wasn't adopted. They really went after it. They tried to simplify and reduce. It got it down to 4,000 words, but that Constitution was rejected. Then if you add the work of the 61 Amendment, that was a wholly new amendment for the judiciary, and the 75 and 77 amendments, you have a Constitution of 16,000 words. It's doubled again. So the question I want to ask in conclusion is, why do we have such a large, complicated judiciary article and so much continued dissatisfaction? Is it just that the justice is so important that we have to put all that detail in there? Is it that the supply simply has not kept up with the demand and we have to keep adding and changing? Is it that the details are meant to prevent a runaway legislature from, if it had the discretion, to politicize the courts? Or is it the framework and assumptions that we take into writing a judiciary article that need re-examining? I'm not sure which it is and whether we have to make those choices, but let me conclude by a remark by a famous, rather sour-minded writer, Samuel Beckett, wrote a novel in 1946 called Mercier and Camier, and he said this: "We must choose," said Mercier. "Between what?" said Camier. "Ruin and collapse," said Mercier. "Could we not somehow combine them?" said Mercier. So I leave it for the second panel to decide whether we're caught in a Beckett dilemma or whether there is a way out. Thank you.
Thank you, Professor Gailey, for that fabulous talk. You're in for a treat. I want everybody to sort of, in your mind's eye, take yourself back almost exactly 50 years. The date is April 4, 1967. At about 9:50 at the Albany County Airport, the Chief Judge of the State of New York, Stanley Fold, greeted the Chief Justice of the United States Supreme Court, Earl Warren, who had flown to Albany to deliver the keynote address of the 1967 convention. 2 hours later, at 12:09, in the New York State Assembly chamber, which was crowded to the doors, Earl Warren delivered the keynote address in which he admonished the delegates of that convention to protect fundamental rights and for New York to do its part as a state actor in a federalist society and aggressively defend rights. He was followed to the podium by the governor of the state of New York, Nelson Rockefeller, was followed then by the senior senator of New York State, Jacob Javits, and then was followed by the junior senator, soon-to-be candidate for president, Robert Kennedy. 5 months later, the convention produced its work product, and in November of 1967, because the convention decided to give the voters a single up or down choice, yes or no, as to their work product, voted no. Fast forward 50 years. As Chief Judge DiFiore said, we are but 8 months away from New Yorkers around the state going to their ballot places and looking at a 13-word referendum question. Shall there be a convention to revise the Constitution and amend the same? A 30-something-year-old lawyer in 1968, who had just been a participant in that convention, wrote an article, it's in your materials, talking about what just happened, and he noted that a fascinating aspect of constitutional conventions is the almost willful neglect of the past in organizing them. One reason, he said, is that conventions are separated by at least a generation of the public lives of men, very few of who survive to tell the story the next time a convention comes around. Well, no one in this room this evening will be guilty of that willful neglect. And we are blessed because we have three public men who have seen everything, done everything, know everything about state government, who can tell us what it was like during those 5 months in Albany during the Constitutional Convention. Their biographies we could spend the whole evening talking about, so I'm not going to do that. But I will just note very quickly, to my immediate right, for those of you, one of the extraordinarily most accomplished New York lawyers, investment bankers, government officials, Ambassador William Vanden Heuvel. Yes, Ambassador. He spent some time in the United Nations. His career began as a protege of the founder of the CIA's predecessor, Wild Bill Donovan. He was a member of the John F. Kennedy presidential administration. He served under Robert Kennedy when he was Attorney General, and he was, yes, the vice president, or one of them, of the 1967 Constitutional Convention. To my immediate left, Michael Del Judas is a legend in Albany for all the right reasons. He has seen everything, done everything, and knows everything. He was the chief of staff to Mario Cuomo. He was the director of state operations to Hugh Carey. He was the chief of staff to a New York State speaker, and he was a senior staffer of the preparatory commission that prepared the delegates for the '67 convention. And to Michael's immediate left, Hank DeLay is, there's no one else that knows as much about the '67 convention than him. He literally wrote the book about it. Himself, an extraordinarily accomplished public servant. For many years, director of state operations under Governor Cuomo. He served in the Carey administration as an assistant secretary with the education portfolio. As a young staffer in the Assembly, he got to witness the '67 convention, and after his stint in public service for many years was an esteemed vice president at Cornell University. We are blessed to have these three men in front of you, and I'm going to stop talking, and we should start listening to what they have to say. And I'll have some questions, but let me begin with the ambassador and just say, tell us what your interest was that led you to participating in the convention as a delegate and a vice president.
Thank you very much, Hank. Chief Judge Fiore, honored to have you here tonight and to meet you. And colleagues, Professor, that was a very interesting lecture about our days. Can everybody hear me? No. Can you hear me now? Okay, thank you. Those were tumultuous days. John Kennedy had been murdered in 1963. I was the senior New Yorker on Robert Kennedy's staff as Attorney General. And when he determined that he was going to run for the Senate in New York, I came back to New York with him, and we undertook what was certainly one of the great extraordinary adventures in American politics. Succeeding President Kennedy, of course, was a giant of a political legend, Lyndon Johnson, and who accomplished extraordinary things with the New Deal majorities that were given to him by the voters. But among other things, of course, he had an animus for Robert Kennedy, that made it very difficult to establish what was happening and what was being done to whom. New York was an extraordinary thing at that time. I mean, you had Haverhill Harriman as governor, you had Nelson Rockefeller, a national, international figure. You had Jake Javits, who was certainly one of the most able senators in the 20th century. And so the question frequently was, is Robert Kennedy going to play a role in New York? Or is this just a platform for the presidency? And so in 1965, 66, that was tested, and among the issues that tested him was a role in the Constitutional Convention. And I had the privilege of being his assistant and his aide and in the position of executing many of the things that were done relating to the convention. There were wonderful people at that convention. When I think of Charles Desmond, who was the chief judge of the Court of Appeals, Charles Roselle, who was a judge from Queens, a man of great understanding, wit, and intelligence. There were all kinds of individuals at that convention, and you wondered how we could possibly pull it all together to do what I think most people wanted to do, which was to write a modern constitution for a modern state. Everybody's reflected on the length of the Constitution, the unreadability of it, the hodgepodge character of it in many ways. Well, a lot of us set out to do things that we changed that. Our candidate for the presidency of the convention was Charles Desmond, but Nelson Rockefeller's candidate was Tony Travia. And one of the things that I think made it difficult for the convention to be ultimately successful was that the real political power of the state was not represented in the convention. It was represented by those on the outside looking in and deciding what and what they would not do. Nelson Rockefeller played a commanding role in many instances, certainly by the choice of Travia. And Travia was an excellent president in our experience and a man with much to admire. The basic questions that were before the convention were the questions that deserved constitutional understanding and treatment. Reapportionment. The Blaine Amendment, which is not even talked about anymore, was the commanding issue of that convention. Among those who were there on April 4th, 1967, was Francis Cardinal Spellman. And the Catholic population in the state, which at that time measured, I think, 40% of the people of the state, their hierarchy was determined to repeal the Blaine Amendment, which had somehow or other ended up in our Constitution in 1994 as the work of James G. Blaine, the continental lawyer from the state of Maine, who had run against Grover Cleveland for president. And this Blaine Amendment essentially stated the American doctrine of separation of church and state. But things were changing, and there were many programs and issues there. The hierarchy in the other private schools felt that children should be treated by the state as what their basic needs were, and not on the basis of the separation of church and state. That became an overwhelming issue at this convention. The issue that interested the governor the most was the community development issue. Then there was the question of the judiciary. And it was interesting for those of us who knew we would never sit on a court probably, to watch judges behave. It was a very real fracas. And a lot of words were spoken in the course of that convention to each other and to the convention that left people's hair standing, frankly. And then the fact that so many people were there to protect and defend their personal interest, or as they saw it. So what you need in a constitution, which is a document that hopefully resolves the political, economic, and social dilemmas and separations among people, which requires nonpartisan minds in such a respect, not much of that was there when you got to discussing issues like the judiciary. Referenda are very difficult things to manage. We've seen that in our own day. We've seen Brexit, what happens when you let loose in a representative democracy the opportunity to vote on a single issue where there are forces that are collected to make it happen. And so a referendum is probably not the best means by which you can adopt and to reform a constitution. And I think there were so many things, for example, in the judiciary article, which is of most interest here, the person that we counted on to hold it together and to make was Jack Weinstein, who many of you know as the former chief judge of the Eastern District. Well, Jack was someone greatly esteemed by those of us who worked with him. But unfortunately or fortunately for him, at the very moment that we were to start the convention, and he was the executive director of the Judiciary Committee, he got the federal appointment through Robert Kennedy to the Eastern District and left us. Would have made a big difference. We had just gone through the election, well, the election of '66 itself, where all of us were elected, et cetera, was something to remember. You had Frank O'Connor running, and you had the Liberal Party nominating Franklin D. Roosevelt, Jr. So the Democratic Party was extraordinarily divided in that context. You had a convention where Howard Samuels at first established himself as an upstate businessman who had ambitions to be governor, properly so. And he was one of those who really pushed for the convention to be organized. And he pushed it on the basis of one man, one vote, which the Supreme Court had only decided in '64, arguing that we should have a unicameral legislature in the light of that vote, rather than the bicameral legislature that we had. Jack Weinstein was Robert Kennedy's candidate to be Attorney General in that election. And when we turned our heads for a brief moment, we got Mayor Sedita of Buffalo. I never forgot his opening words as he accepted the nomination is, "I am the best mayor that money can buy." So we had a candidate also for lieutenant governor that we thought was awfully good, Orrin Lehman. And instead of Orrin winning the nomination, when Bobby decided to go back to New York, Ray Jones and others turned that convention around and nominated Howard Samuels. So there was a lot of feeling in the air. I think Frank Hogan had emerged from that convention himself as a candidate for the Senate, the United States Senate. And so the liberals and the conservatives were bitterly divided. In any event, Bobby decided that he was going to play as significant a role as he could in the convention, and I had the privilege of being identified as a Kennedy spokesman on many issues, and treated as he would have been treated, hooted, booted, yelled at, all the other things that you can go through in a constitution. But I'll tell you, there was an experience, and we'll get to whether you recommend or not recommend that we have another Constitution Convention. But it was an experience where the issues that made up our state were debated and effectively challenged and discussed more than in any other forum that I can imagine in recent years. Many of the people who were at the convention, the younger people, use it as a major mark forward in their own careers and end up in very significant posts in the federal and states and local governments in the state. But what definitely came out of that convention was a generation that understood what the problems of our state were, and that gave significant understanding to what should be done about them. And over a course of years, I think ultimately we would say it worked. Thank you.
Hi, Mike Del Judas. I'm glad we're not standing up. Makes it a lot easier to talk. I was, as you said, Hank, on the way over here in the cab, I was saying, how many people are going to be there tonight to talk about the Constitutional Convention? So, like Hank, it's kind of pleasing. Either you have no social life, or you're here to learn something interesting. I got involved in New York State politics when, in 1964, with a fellow named Gene Nickerson, who was a county executive in Nassau County, the only Democratic, I think, elected official in the state during that time. The entire rest of the state, I guess it was Travia and Zaretsky were still in at that time. There was a 4-year period of time when, after 1964, that the Democrats had control of the Senate and the Assembly. That's the period that we're talking about. After that, it went back to Republican for a long period of time until you carry. But I got involved very early in the Temporary State Commission to revise the Constitution. I had been working in Nassau County, as I said, and one of my bosses was introduced to the executive director of the commission, a fellow named Sol Corbin. Some of you may know him or know of him, but he was a counsel to Nelson Rockefeller, very brilliant, very hard-nosed, very tough guy. When I used to write some papers and occasionally it had to go through Sol, he would just rip them up and shred them. So he gave everybody a good learning experience in the process. The temporary commission, I think, is an important part if there is going to be a convention, that a temporary commission be established. And the governor proposed an amount of money last year, I think $1 million. The legislature took it out, so it's still not available, but presumably it will be added to the budget if this fall happens. The commission was staffed by just a couple of things. It was staffed by professionals who knew, mostly legal, knew about the issues, but it was driven in part, like everything else related to this whole process, by the politics. And even the commission members, who were very smart members from all around the state, took their sides and their positions, and it was a very hard-nosed battle. Even getting to the point of establishing the commission was fraught with a lot of political problems. I think it was created early in the year. It didn't get around to being finally appointed when Sol became chairman in December, and it had to produce a report in March. So it was literally 100 days. And when I got there, we worked around the clock that period of time to produce some reports, most of which I thought were pretty good. Some of them were not. But the importance of having a temporary commission beforehand is to lay out the issues. And to put, what we decided to do was a big decision, how to write the report. Should it take a position? Should it give the pros and cons? And so ultimately it wound up being, I guess, 30 or so books, which I still have 300 copies of in case anybody wants a copy. I do actually have 300 copies. We had them left over. Nobody wanted them, so they were all done. But they were very well written books by the time they were done and laid out pros and cons. And I think they were useful for the initial delegates that got elected. But I think one of the main issues that needs to be confronted is who the delegates are and how they get selected. I think the governor in this current position has said he would like legislators not to be delegates. It's hard to prevent people not to run, so that's going to be an interesting battle as to how this plays out. That is the selection of the delegate process. But laying out the issues and analyze them in a deep way is the only way you can really understand the process. Once it gets into the convention, of course, then politics takes hold. And that whole process, as Bill described, played out, and Hank will describe, in a very tough way. The bad part of the convention, I think, in '67 was that the legislature controlled so much of it. And as Bill said, it was hinged on one issue. I ran for Congress in 1968 at age 25. And even before that, the Blaine issue, aid to parochial schools, was like the dominant issue of the time. You had to decide whether you were for it or whether you were against it. That defined your democratic politics. Today, we don't have so much of an overriding single issue, I think. A lot of the social issues that were troublesome during that time have passed, and now it's more, what kind of government do you want, how to refine it, how to make it operate better. It's much more of a mechanical, I think, kind of judgment. So if there is to be a vote on the convention, I'm not quite sure how it'll turn out this fall. We'll see. It's an off year, meaning statewide. There are no statewide officials running. It's an on year for the New York City mayoralty. In cases where there are referenda, usually that's the kind of year you want to have, if you're for it, you want to have an amendment on the ballot, because New York City will turn out, New York City votes everything yes, and so upstate votes everything no, but it turns out in non-statewide elections, 60% of the vote usually comes out of New York City, so the referenda usually win. When we decide what years to put referenda on the ballots, it's in the New York City election year. If it's not in the New York City election year, you lose. It took a long while for people to figure that out, but that's the way it works. So we'll see how it turns out. I think it'll be an interesting process. If it goes forward, I would encourage you to perhaps consider running for delegate. It's a fascinating process. I learned more at age, whatever I was, 22, 23, in 100 days than I could have learned in 10 years, just getting deep into the process and working with people who were heavily involved in it. So it's an interesting time. In many ways, it's an academic discussion, but you know, when you talk about not life and death in this case, but you know, aid to parochial schools or the structure of the courts, why there were so many pages on the court in the Constitution is because lawyers write it. And they have to keep talking, so that's what happens. But anyhow, I would encourage you to certainly follow the process, but if possible, to think about running as a delegate. Would be interesting. Hank?
Well, good evening, everyone. My name is Hank DeLay, and it's my great pleasure to be on this panel, both with my good friend and fellow colleague during the Mario Cuomo years, Mike Del Judas, and my colleague on the hustings talking about constitutional conventions, Peter Galie, and one of the real heroes of the 1967 convention, Bill Vanden Heuvel. Hank Greenberg asked us all to sort of begin by saying, how do we get into this discussion to begin with? And I came to Albany in January 1965 as a result of the Lyndon Johnson landslide. It produced the unthinkable, namely a Democratic majority in both houses of the legislature. Hadn't happened since the Great Depression.
And hasn't happened, well, happened
Well,
once
right.
since then.
I went to work as a budget analyst for both the Ways and Means Committee in the Assembly and the Senate Finance Committee. We had very, very small staff at the time. And I confess, I had never, ever thought about the New York State Constitution until that time. Well, that changed pretty quickly for me. The first year of a Democratic majority in the legislature was absolute chaos. Factional strife here in the city prevented the election of Democratic legislative leaders for more than a month, with the Republicans finally weighing in after they started being criticized for it as well, to give their support to Anthony Travia and Joe Zaretsky, who had been the previous minority leaders in the legislature. They started to move the legislative session forward, but the very structure of the legislature was under attack, you might say, as a result of the reapportionment decisions taking place at the national level. The United States Supreme Court had handed down Baker versus Carr, and then Reynolds versus Sims applied to the states. And right here in New York, it was a radio station, WMCA versus John Lomenzo, the Secretary of State, that made the decision applying it to the New York State legislature. And one person, one vote became the standard. Life with the courts at that time was interesting because the Republicans, having just lost the election in November of 1964, said, okay, we're going to pass 4 alternative reapportionment plans. Maybe one of them will stick. Each one perhaps more conservative than the other from their perspective. And by conservative, I mean giving them a better chance of a majority. And the courts had a grand time. The federal courts ultimately threw out 3 of the 4. The Court of Appeals then threw out the 4th one. And the federal courts then told the Court of Appeals, get out of the way, we're taking charge of this. It was chaos. People who had been elected for a 2-year term in November of 1964 were told that they were no longer going to serve for 2 years. They were going to have to run for re-election immediately in November of 1965. It was in this environment that the Democrats, who had since the days of 1915, when Al Smith, God rest his soul, said that New York was constitutionally Republican, the Democrats had been pleading for constitutional relief on the reapportionment article of the Constitution to give all these immigrants in the urban areas an opportunity to weigh in and have a chance at getting a majority. So the legislature passed special legislation putting the question on the ballot, out of order, out of the 20-year sequence. And in November of 1965, Governor Rockefeller signed the legislation. Speaking of temporary commissions, Mike, he had been the chair of Averell Harriman's commission appointed before 1957. In fact, Harriman wasn't very happy with the fact that Nelson went around the state talking about the Constitution and decided, hey, this is kind of fun, I might even run for governor. Oh, well. So unlike their decision in 1957, the voters this time said, yes, let's have a convention. And for me personally, it was, oh boy, I've got a chance actually now to write a doctoral dissertation and spend every day at the convention producing, for your information, charter revision in the Empire State, available through Amazon.com. Now, it's already been mentioned that reapportionment was very significant, but you know, the courts had really made all the decisions by the time the convention came into operation. New district lines had been imposed, and delegate selection, other than for the 15 at-large who were going to be elected statewide, and Bill was one of those at-large delegates, selecting the 3 delegates from each senatorial district, which is what the Constitution requires, that's way down at the bottom of the ballot. Not many people were paying attention to it. They were paying attention to the gubernatorial race between, on the Republican ticket, Nelson Rockefeller and Malcolm Wilson, against Frank O'Connor of Queens, the district attorney, and as you've heard, Howard Samuels for lieutenant governor. Mike has just indicated the Blaine Amendment issue was really the only issue that delegates were called being pressed on during the election period. There was not an upswing of other issues that were confronting everyone, other than the reapportionment issue, but that's, you know, they're in the courts. So most of the delegates who were elected, other than perhaps what I would refer to as a lot of the reformers on the at-large slate, came to Albany in 1967 with a relatively blank slate. Some people just said it was an empty brain. No, it was a blank slate. Little reason for change. You've heard that the opening day was quite a show. The Chief Justice of the United States, Senator Javits, Senator Kennedy, Governor Rockefeller, all there, the Cardinal giving the blessing. Travia had been selected in part with the support of Governor Rockefeller, but also in part because he promised that he could organize the convention and get it running quickly. He pointed to the 38 convention, which had been led by the Chief Judge of the Court of Appeals, Frederick Crane. That was seen as a less partisan endeavor, which took forever to organize. They ended up with some 35 committees or so, took forever. Travia promised, we ain't gonna have that happen again. Travia promised, quote, a new and simple constitution that will permit our states and localities to solve their problems in a working partnership with the federal government. That theme of freeing the state from restrictions in the Constitution so that it could effectively participate with the emerging programs of the Great Society was a theme that ultimately had a lot of attention during the convention. Now, who were the delegates? There were 186 delegates. They included a member of the United Nations staff, a sitting member of Congress, 13 sitting state legislators. Hold on. 28 sitting or retired judges, including 2 sitting members of the Court of Appeals and the presiding judges of the first and second departments. Former and future mayors of the city of New York, Robert Wagner, Abe Beame, David Dinkins, all delegates. 10 women out of 186, 13 Black and Hispanic members, a cross-section of local officials, mayors, local attorneys. Speaking of attorneys, lots of attorneys. The largest occupational group in the convention, 67% of them attorneys. The lack of a clear consensus reform agenda ultimately spelled doom for structural reform in the Constitution, whether in the executive, judicial, or legislative branches, or in the sections dealing with local government and finance. The election of the legislative leaders of both parties, Travia for the Democrats and Earl Bridges, the leader of the Senate for the Republicans, made clear that there would be no fundamental changes in the legislature's operations other than increasing its own responsibilities. It should be perhaps of particular interest to this audience that proposed structural changes in the judiciary article proved to be among the most contentious issues of the convention. The suggested merger of most of the state's trial courts into Supreme Court, the appointment rather than the election of many judges, including judges of the Court of Appeals, the substitution of primaries for nominating conventions, the administration of the entire system by the Court of Appeals, and the responsibility for the appointment of local non-judicial personnel were issues that divided the delegates. For the most part, suggestions for judicial system change were handily defeated. But the Constitutional Convention provided an opportunity for those important questions to be publicly debated in a way that was simply not possible in the normal legislative sessions. Now, given the sponsorship of this evening's event, I should note that the behavior of a number of the judges serving as delegates was occasionally a cause for scandal. Ambassador Vanden Heuvel has already mentioned it. The administrative judge of the Supreme Court here in Manhattan, Saul Street, was particularly at fault. Early in the debates, he had made fun of the, quote, little lady who chaired the Judiciary Committee of the New York State League of Women Voters, Betty Schack, suggesting that she had no business making recommendations to the convention since she was not herself a judge. Now, that personal criticism was certainly a factor in the League's ultimate opposition to the entire Constitution. In the closing days of the convention, Street made fun of another delegate's name, producing boos from the rest of the delegates and guaranteeing from that point forward that anything Street opposed would receive overwhelming support. And indeed it did. Seeing some of these judges in action was an eye-opener for both the other delegates and for the media. Imagine, they said, what it must be for some of the attorneys who have to practice before these individuals. When it became clear that structural reforms were going nowhere, the Democratic leaders turned to a number of important policy objectives in hope of securing popular support for the final product. Late in the convention's deliberations, they obtained majorities for the phased-in state takeover of the costs of local welfare programs, including Medicaid. Now, that didn't just come up in the Republican plan for the Affordable Care Act repeal of a few weeks ago. 50 years ago, the convention was proposing to take over that local share of not just Medicaid, but all local welfare. The phased-in state takeover of the local costs of the unified court system, revised standards for aid to public schools, and a new community development program that envisioned public-private partnerships to alleviate poverty, expand public housing, and strengthen social services. These initiatives were popular with the Democratic delegates, but they generated intense opposition from both their Republican counterparts and fiscal conservatives in the general public. When the final decision was made on the last day of the 1967 convention to submit its work as a single package, an all or nothing, take it or leave it proposition, the public's rejection was overwhelming. The conflicts among religious groups over the repeal of the Blaine Amendment and its substitution by the language of the First Amendment to the United States Constitution had soured much of the public's perception of the convention, excuse me, and the fiscal debates over the majority's programmatic initiatives gave the impression of a unicameral legislature gone wild without the discipline of a gubernatorial veto. I've written that the 1967 convention was, quote, a magnificent failure. It failed to secure a majority vote in favor of its final product, but many of its initiatives were subsequently adopted, while others remain outstanding with us today. So again, it's a great pleasure for me to be on this panel with my colleagues, and I thank you very much for your attention.
So I have one quick question for each panelist, and then we'll hear from the next panel. But Ambassador, help us to get a feeling for what it was like to be on the floor of the convention as a leader of the convention. How was it in the sense of, did it feel like a partisan political fight or a high-minded discussion of fundamental freedoms? What was it like for you?
I think as someone suggested, had we seated the delegates...
If you could speak.
Had we seated the delegates... Can you hear? Had we seated the delegates alphabetically instead of by party, there's a possibility that you would have had a different chemistry in that situation. And I'm sorry we didn't try it at least, but we were divided from the beginning, and one side and the other. And Earl Bridges was a brilliant manager of the Republican Party, and Tony Travia was an equally brilliant leader for the Democrats. So that from the very beginning, the partisan nature of it was there. But on the other hand, partisanship has divided every political institution in this country, and it's still, we've had a lot of things that were possible to be done. The finer moments in the convention were things like the suggestion that higher education in New York be free. I mean, this is 50 years ago, and we were talking about that. We were talking, Peter Crotty from Buffalo was the chairman of the Labor Committee, and he had in the language of the Labor Committee that labor is not a commodity. And there was if we had been able to adopt this, I think we would have succeeded in many ways in changing the nature of that Constitution itself. I've always felt that to prepare for a constitution convention is absolutely essential. And I was a great admirer of John MacDonald, who was a professor at Cornell University, who was essentially the founder of the Law Revision Commission. And I think what should have been established was a permanent commission for the consideration of amendments and changes to the Constitution. And I think we would have had, if we'd had an interim body like that made reports and followed and worked with the convention, I think we would have had a more successful time. But as Hank has said, this was a magnificent failure, and much of it was subsequently enacted by the legislature. And I think if we take some time and study what we didn't do correctly in 1967, that it's possible to get a very successful convention out of the next one.
Michael, the 67 convention, there were, I think, 186 delegates. If there was a convention called for 2019, there'd be 204 delegates. In 1967, where did the staff come from for the convention? How important were they, not just in the preparatory work, but the operation of that 5-month convention?
Well, as it turns out, given the fact that the governor wanted Speaker Travia to be the chairman of the convention, it was pretty easy. It was Hank and about 20 of his colleagues who worked on the Assembly Ways and Means Committee that really were the staff of it. So it was really very much an institutionalized legislative effort, and it was totally controlled by both by Travia and by Rockefeller.
But I think it's fair to say, isn't it, Mike,
I'm sorry?
that Travia insisted that the staff be nonpartisan.
Yeah.
And the quality of the staff in the convention is something to really be registered. And that was because of Tony Traurig, perhaps Nelson Rockefeller too. Certain Robert Kennedy insisted upon. You had people in the convention like Alan Campbell, who went on to become head of the civil service in the country. And he had as his staff assistant Donna Shalala, who we all know from a different career. But there were really outstanding members of the staff.
Yeah, it was a great spawning ground for a lot of folks, both on the staff level and the delegate level, who then stayed in politics, which was obviously very good. And I think, as Hank pointed out and Bill mentioned, I would say 70% of the proposals that were in that convention, in that document, ultimately became law. And maybe, you know, in retrospect, the fact that they became law in their time was better than having it done all at once. The mistake is getting a highly controversial issue like the Blaine Amendment to be the spark plug of the whole debate, and that covered everything. And it was simply up or down.
Totally illogical to have a single vote on the Constitution. The logic was, if the Catholic community was so interested in the Blaine Amendment, we gave that to them. Early in the convention, the repeal of the Blaine Amendment was agreed to. Well, if this was going to bring out a tremendous number of maybe conservative voters, then the liberal part of the Constitution would bring out others. So we thought that there would be a merger of the liberals and conservatives' interests that would compel each to vote for the Constitution.
Hank, let me just mention the Donna Shalala. We got two dissertations out of this 1968. Donna Shalala did her dissertation on the 1968 convention. She called it The City and the Constitution. She focused on city urban issues, but she also went on to be a successful PhD on the 67 convention.
So finally, Hank, many people, the last time there was a debate over whether to have a convention 20 years ago in 1997, and then 20 years prior in 1977, critics of a potential convention, both referendums pointed to the 67 convention as Exhibit A, why New York should not do that again. You come to a different conclusion. What is it about the 67 convention that gives you hope that things might turn out differently this time around if the voters say yes?
Well, I think in 1977, it was a short period of time, 10 years, since the 67 demise. And people remembered the acrimony that had been created, especially by the Blaine debate, and were uncertain about going into that again. By 1997, I think we had a different dynamic. People, if you looked at polling, and they did polling from the Siena Research Institute, going right up to the question in November of 1997, and people were saying yes, they were inclined to vote in support of having a convention. But then we had about 10 days of intense advertising by the public employee unions in opposition. They had decided, to me, beyond the facts, that a convention was a threat to the provision of the Constitution, which guarantees that their public pensions shall be neither reduced or impaired. And all over the state, these television ads came up and so forth. That same pattern is happening right now. The teachers' union and so forth. And if you are to look across the country, it is happening in other states. The basic argument, I think, today, given the strength of the unions in the public sector, is that they own the process as it is. I've heard many a leader say the process sucks, but we run it. We know how to operate it. They pay, they're the largest lobbying expense group in the state last year, in 2015. NYSA and UUP were the single largest lobbying spenders. They do it across parties. They make sure that the majorities in both houses support are supported by them, and they in turn say, well, we're not going to upset your apple cart. I think it's time to upset the apple cart. I think it's time when we have one leader after another of our legislature being indicted, convicted, going to jail. It's not just limited to the legislature. I don't mean to criticize them only. We've got a former state comptroller in prison right now as well. We have people close to the governor under indictment. One of the advantages of a constitutional convention is that it brings together this mix of people, not simply office holders, but also in the last convention, social workers, teachers, automobile dealers, et cetera, along with, as I said, a lot of lawyers, who are not wedded to all of the details of the existing structure and can look at whether we have term limits for members, term limits for leaders, whether we have changes on this infamous message of necessity process that causes budgets to be passed when nobody knows what's in them because we excuse the 3-day requirement the bills be on the desk of members so that at least the member has a chance to read the bill, let alone the public. I mean, there are a host of things that need fundamental attention by people with common sense, and I think you can get that in a constitutional convention if you are prepared to run for it, as Michael has urged all of you in this audience to consider doing, but also if there is a consensus reform agenda that people can rally around, so going into a convention, people know what they're going to try to achieve.
I think it should also be said, though, that the issue that really defeated the Constitution was finances. Once the convention adjourned, the campaign against it that was very well organized and very well financed argued that to adopt this Constitution would bankrupt the state. And that was the issue, I think, that most people voted on. And if we are to organize another constitutional convention, there had better be a group that's working at the same time, how do you present it to the people of the state so that they understand the positive aspects of it. I think it's true also that this Bar Association supported it, didn't it, Hank?
97?
Yeah.
No,
I mean, the Bar Association is 67.
Opposed the convention in 97.
No, but it passed, supported the Constitution. This Bar Association.
Oh, the 67 Constitution.
Yeah. This Bar Association was one of the major groups in the state that supported it.
Well, I think all of us in this room feel a debt of gratitude to these three great New Yorkers and public servants for taking the time to share their thoughts with us.
Well, our next panel will answer the following question. Why should lawyers care about a constitutional convention? We have a whole lot of lawyers here, so we're going to explore that. Let me first just get up our next PowerPoint. I may need some technical assistance to do that, yeah. So there was a question asked that I think we've heard three different answers to, which is why should lawyers care about this? There's one word, the judiciary. And why is that last slide up there showing that the judiciary article is longer than the U.S. Constitution, 4 times as long as it's ever been? Why? Because we have the most complex court system in America, if not the world, here in New York. We have 11 trial courts, twice as many as any other state, and that's because of our Constitution. Our Constitution judiciary article is like the operating system of our court system. It sets out the structure. And there's one word that starts the judiciary article, or one sentence, which is probably the biggest oxymoron ever written in a constitutional document. There shall be a unified court system for the state. Our court system, as you know, is anything but unified. We have a brief look at it here. This is from the court website, which shows just how complicated our structure is. We have a brief history of this, which I'm not going to go through, but it goes back to the colonial era, which is why we have the division between law and equity. Our first real judiciary article is in 1846. We have a 150-year-old judiciary article. I don't think anybody would say a court system designed in 1846 is a court system we should have today. 1894, we have a retirement age of 70 set for our judges. That was life tenure. It's still the retirement age today. The last major change in the court system was 1977, 40 years ago, where we had 3 constitutional amendments. So we have a true dream team of the judiciary up here today. I'm going to start with my far right, Judge Alan Schenkman, who is the administrative judge of the 9th District, and also the co-chair of Chief Judge DiFiore's Committee on the Constitutional Convention. To my right, Judge Janet Ruiz, who's the administrative judge of the New York City Family Court, probably one of the most important and yet complex court systems. It could be a whole court system of its own. To my far left, Carrie Dunn, who is the general counsel for the New York County DA, and he chaired something called the Commission on the Future of the New York Courts, and we're still looking for that future. We'll get to that in a minute. And to my immediate left, Mark Blaustein, who is the resident expert on all things constitutional and the judiciary article, who's told me earlier that one reason why this court system is so complex in the Constitution was it paid for the tuition bills of his 2 kids to go through college, because we have to have Mark around. So Mark, I want to start with you. We saw what we call the Tweed Commission make these changes in the 1960s. Then we saw coalescing in the 1977 court reform, vote for 1, 2, 3. What were the kinds of political forces that can make more than just lawyers care about amending the Constitution to make for a more efficient judiciary?
Before I answer that question, or try to, let me just clarify something Steve just said. Mm-hmm. What I actually said was, I started my career about 40-some-odd years ago working for the court system. I was a law clerk to Dick Bartlett, who was at the time the state administrative judge, soon to be the first chief administrative judge of the state. And in 1976, I actually helped counsel for the governor to draft the court consolidation amendment that had been recommended by Cyrus Vance's commission, the task force that had been set up by Governor Carey when he first took office to study court reform. And after that exercise, it seemed like every year, every 2 years, I was being asked to come over to the governor's office and help write yet another iteration of a court consolidation amendment or some other form of court reform. And this continued, in fact, it's continued almost to this very day. And I've spoken many times about court consolidation, and invariably I start my remarks by saying something like, well, you'd think that I would be really a fond supporter of it, but actually it was exactly the opposite. I was really against it because I got to support my family on the backs of this, which included sending 2 children to ridiculously expensive private colleges. So anyway, that's the true story. But to answer your question, the Tweed Commission, first of all, who was Tweed? It was not Boss Tweed. It was a lawyer from New York City by the name of Harrison Tweed, a lion of the bar at the time. Why Tweed and why a commission? This is oversimplifying it a bit, but go back to 1945. World War II had just ended, and the GIs were coming home. One of the things that all observed in the United States in the post-war period and also in New York was that there was a proliferation of automobiles. And with the proliferation of automobiles, automobile use, there were lots of accidents. And with lots of accidents, there were lots of lawsuits. And so the tort calendar in the state began to grow like topsy. and in some measure to overwhelm the state's management capabilities, management of the court system and the court system's resources. At the same time, the cities of the state were growing, and with that growth, there were new forms of poverty and crime, and so the criminal caseload was growing apace as well. And so recognizing this, Governor Dewey in 1953 called upon the state legislature to set up a temporary state commission to study the courts. He did that. The legislature accommodated, and Harrison Tweed was named to chair this commission, which produced its first of 5 reports beginning in 1954 and culminating in 1958. These reports called for a variety of court reforms. Significantly at the end, there were a bunch, but the 2 that most stand out for me, one was the recommendation that there be a unified family court for the state. Up until that time, there were courts upstate. They were called children's courts and a domestic relations court for the city of New York. These were legislative creations dating from authority that the legislature had been given back in the 20s. That was one big reform. The second big reform was in the management of the court system. Up until that time, although the appellate divisions exercised some limited oversight of the way trial courts did their business, by and large, those courts were creatures of the local governments that they served, and they pretty well ran themselves. And so the Tweed Commission recommended that, all right, let's start to inject at least some regional management of the courts so we can do things better. And so they proposed a system whereby the appellate divisions would be responsible for the day-to-day supervision of the courts. Policy for the state would be set by an administrative board of the Judicial Conference. The administrative board would consist of the chief judge of the state and the presiding justices of the 4 departments, and together they would set policy for the state.
And then, Mark, no more than about 10 years later, we have a basic state takeover with a centralized court system in the 70s. What were the forces that led to that?
Well, there were a bunch of things. I mean, the 70s, we're talking about 4 basic changes in law, 3 in the Constitution, 1 by statute. One is the takeover of court funding, which was a statutory thing done by the legislature in the summer of 1976. And then there were 3 proposed constitutional amendments, one to make the Court of Appeals an appointive court, and one to reform the Commission on Judicial Conduct, basically to do away with this thing that was called the Court on the Judiciary, which had been the supervising body for errant judges up until then. And the last change was one in court management. And if I may, the reason that change in particular was recommended, and that was a change to give Judge DiFiore the ultimate say in terms of the policy for the state, and her deputy, the chief administrative judge of the state, responsibility for supervising day-to-day the trial court operations in the state. The reason that came along was in the wake of Tweed, and then the Judicial Conference weighed in with some suggested amendments at the end of the 50s, and then ultimately 1962 came along and we had a new Article 6 that embodied most of what Tweed had recommended. It became evident even shortly after the 62 amendments that they weren't quite up to it, and caseloads continued to grow like topsy, and that some further changes were in order, one being the centralized management under the chief judge and chief administrative judge. At the same time, the state was experiencing, as was the country, a fiscal calamity, and so it was pretty clear that the state would have to step in and help localities in terms of funding the courts. And then the last thing, with respect to the Court of Appeals, I'll mention, is that the state, up until then, the Court of Appeals was an elective court, but throughout the late 60s and early 70s, and most notoriously in 1973, there were very, very expensive and nasty campaigns for seats on the Court of Appeals. The one in 1973 was between Charles Bartel and Jacob Fuchsberg. And I think many people got the idea that it was unseemly and unhelpful to have the state continue with an elective system for its highest court. So those were a lot of the factors. There are other things I could say, but those were the basic factors.
Let me throw in one other factor that Mike Cardozo always brings out, which is that the business community coalesced along with a number of good government groups, and the governor was behind it, which really made a big factor. Okay, so let's jump to our next slide. In the year 2006 to 2007, our friend Carrie Dunn was appointed to run the Dunn Commission. One of their recommendations was a centralized court system, a unified court system with a two-tier trial court. Interestingly, this had been proposed back in the Vance Commission days, but left on the table when we came up with a vote for 1, 2, 3 amendments. What led you to produce what Judge Kaye always says, a much prettier chart of the court system? And what do you think led to this particular proposal not coming to be,
Well,
Carrie?
before I get to that, I would say those of you who are students of this topic might be interested in a review I read in the paper this morning about a new Broadway musical that opened yesterday, and it's called Groundhog Day. In terms of what motivated both Judge Kaye to establish this commission that I chaired and what we really brought to it, let me just read one paragraph from the introduction to our report, which really, I think, captures what Judge Kaye had in mind, and I think that gets to the answer of your question. Quote, "For decades, commissions, scholars, legislative panels, and others have decried the inefficient and wasteful structure of the New York courts and have advanced myriad proposals for reform. Time after time, these efforts have stalled, not for lack of popular support, but for lack of political will. In this arena, generations of good ideas have been undone by the inertia of the status quo." And so if you look at the history of the different proposals that have been occasioned over time, every 10 or 20 years, depending on who's standing up and calling for this kind of reform, frankly, in terms of the structure, it's not particularly complicated, and ours was not particularly new in 2007. And this does, in fact, come from our report, as I see it now, because it's pretty obvious, but it also mirrors, frankly, what's been done in, the statistics are in the report, but I would say, 97% of the rest of the states across the country have, in their own way, in many years ago in most cases, come up with the same simpler system like that we have in the federal system. And rather than the umpteen different courts of different jurisdiction at the Supreme Court level and their analogs, there is one, and then there's one level of inferior courts, call it what you want, whether it's a district court or something else, and then there's a court of appeals. And we always toyed with whether to change that to the Supreme Court, but that was deemed to be too complicated, blah, blah, blah. But whatever you call these courts, simplifying the structure is not the complicated part of the analysis, it's how to get it done. So if your question is how did we come up with that, it's just pretty damn obvious, I think.
All right, so let's go back to the prior slide. Judge Schenkman, you're in the trenches running a very busy court system in the 9th District. What are the practical constraints that are placed by an organizational chart like this?
Well, if I can, I just want to preface my remarks with 2 observations. First, I was recently asked by Chief Administrative Judge Larry Marks to speak at a law school, and he said, "I'm asking you to do this because I can rely on you not to say anything stupid." So I'm going to try to say, I'm not going to try to say anything stupid, and I also am going to disassociate the Chief Judge and our task force from anything I do say, so that I want to make it clear that I'm speaking solely
as are the rest of your panelists. Yeah.
And I also just want to mention, I don't know if he's still here, but in 1975, when I was a law clerk at the Court of Appeals for Judge Jason, who worked very closely with Judge Breitel on a number of important court reform and court consolidation issues, I met a wonderful man who's here tonight by the name of Mike McEnany. And I would introduce Mike by saying that he invented OCA. Mike, are you here? Yes. I'd like to welcome Mike.
And a matter of personal privilege, I want to welcome him as well, since he was my first boss at OCA.
But to get to your point, Steve, there are obviously a number of critical issues because we have courts that work in different ways on similar types of issues. Here's a classic one that the Court of Appeals just happened to address about a couple of months ago in a case by the name of Archery against Home Plaza, which is you can't sue the state in the Supreme Court. So if you have a situation, simple case, where a person is injured on a road, a state road, because a tree falls down, and there's a claim against the person who owns the tree for not taking care of the tree, and there's a claim against the state for not looking out for trees that might fall down on its roads, those cases can't be heard in the same place. And you have tremendous issues with inconsistent results, not to mention duplication of effort. Why does that happen? In surrogate court, we have a surrogate court that handles estate matters, dead people. Well, we have a growing volume of guardianship cases in the Supreme Court that deals with people who are alive but are not able to take care of their own affairs. So we have Supreme Court judges who appoint and supervise guardians, manage their accounts to make sure that nobody's running off with the money and that everything is being properly attended to. But when that person expires, as we all do, I hate to be a bearer of bad news, but when that happens, then it becomes a surrogate's court case. And that whole file goes over to the surrogate. And you can potentially have a whole different set of players involved in dealing with the affairs of the very same person, which can be a duplication of effort, a duplication of expense, not easy to explain to people. Similarly, let's say you have a wrongful death settlement. Someone is injured, killed in an accident, that if it's an infant, there needs to be court approval. Who approves that? Is that approved by the surrogate, who has the authority over the estate, or is that approved by a Supreme Court judge? And what if those two judges have different philosophies about how to approach issues like attorney's fees? You get a turf war. Is that seemly? How do we manage that? And even when you get to a day-to-day issue, so we happen to have in our district a situation where we had two surrogates leave us. One decided to run for an office that had become vacated because somebody else decided to take a different position. I won't mention who that was. And we had another surrogate who got elected to Supreme Court. In one instance, the governor, after a period of time, filled the vacancy of surrogate with an appointment. In another instance, that vacancy was not filled for a year. Who sits as surrogate? Here's an interesting point. You would think that in a logical world, a logical person to sit as surrogate would be another surrogate. But there is actually a very credible body of view under the state constitution that says you can't do that. That a surrogate from one county, arguably, cannot sit as a surrogate in the adjoining county. So who are you going to use as a surrogate? Well, inside the city of New York, a Supreme Court judge can be a surrogate. Outside the city of New York, a Supreme Court judge cannot be a surrogate. What is the rational basis for that? Who knows? So you could have a county court judge sit as surrogate. County court judges are elected basically to hear criminal cases outside the city of New York. You could have a family court judge sit as a surrogate, but they're elected outside the city of New York to hear family court cases. Who's going to do their work while they're sitting as surrogate? You get these anomalies. You have a situation where we have family court vacancies. Who can sit as a family court judge? Well, outside the city of New York, a city court judge can sit as a family court judge. So we sometimes have orders either on a temporary basis or sometimes on a near permanent basis to have people do that. And that's okay. I have two counties where there are no cities. Rockland County has no city. if you learn nothing else tonight, New City is not actually a city. So there's one point there. So in Rockland County, there are no cities. If, as we were for a period of time without a family court judge, what do? The answer was a city court judge from Westchester. Why? Because we thought that was the place that we could take somebody who would, where that court would be least impacted. Now, is that really the appropriate criteria for figuring out who should sit in a family court in a given county? These are the sorts of issues that we have to grapple with. Here's another little practical one. We have Court of Claims judges. You might want to think, what's the Court of Claims? Don't they hear claims against the state? If you look at the Constitution talks about having between 5 and 8 Court of Claims judges. The fact is, among the real Court of Claims judges, those who are designated really to hear claims against the state, sometimes they're referred to as Part A judges, that they're the real Court of Claims judges. At the moment, there are 17 authorized such positions. There are 95 other authorized Court of Claims positions. None of those 95, by the way, ever hear a claim against the state. But they're Court of Claims judges, basically designated as acting Supreme Court. Why acting Supreme Court? Because under the Constitution, there's no other court that they can be designated to. Most of them sit in criminal terms. Now, it may not make a big difference in the city, because in the city, the Supreme Court has a very vigorous criminal term. Outside the city, as I said, most criminal cases are handled by county court judges who are elected based with the understanding that that's what they're going to do. So when you set up a duty schedule, all right, what judges are going to be handling emergency applications that come in, whether for search warrants or other applications? All right, we've got these county judges, they can do it. Suppose I have a Court of Claims judge who's assigned, who's going to sit criminal. Can that judge sit in the county court? No. So what do? We say, okay, we're going to take all of the criminal cases and we're going to put them in Supreme Court, because we can make the county court judges acting Supreme Court judges, and we'll do everything for Supreme Court. Same thing with grand juries. We can have a county court term of grand jury. We could have a Supreme Court term of grand jury. I have counties where we have no Court of Claims judges. Everything is done by county judges who are elected to do that. I've got other counties where technically everything is run through the Supreme Court, not because we really want to, but because that's the sort of maneuver that we have to do in order to make the system work.
So there's a technical term for this. We call it a hodgepodge, right? So let's turn to you, Judge Ruiz. In the family court, what is one of the most pressing issues a family faces? Divorce. Can you hear a divorce in family court? And what other kinds of practical constraints does our Constitution place on you in running this complex family court system?
Right. So in family court, you cannot hear, family court judges don't have jurisdiction to hear divorce cases. However, we have jurisdiction to hear every other single family court-related matter. And it's really interesting because this notion of really having a full, comprehensive, unified family court, that discussion has been happening since the beginning of the 20th century. And yet we're not there yet. The complexities of having family court matters start in family court. So an example, someone may receive legal counsel that it might be more effective to file a family offense petition in family court, seek a temporary order of protection excluding the spouse from the marital home, and that this might be advantageous ultimately when that person then turns around and, receives an order in family court of exclusion and then goes to Supreme Court to file a marital action and seeking to consolidate, of course, whatever is happening in family court, and that might be a very advantageous thing to do. So there's a host of issues related to forum shopping and to manipulating, if you will, the court system. And of course, more importantly, there's harm to families and children, and families who can't have all of their family court matters heard in one court. Families have to sometimes, well, we see it mostly in two areas. We see it in the divorce area, but there was also the creation of the IDV courts, the Integrated Domestic Violence Court, which also was something that Judge Kaye also was very concerned about and created those courts, because victims of domestic violence were also caught in the same quagmire of having to go to multiple courts to seek judicial relief, and all that comes with that. Because not just going to multiple courts for families, the other issues associated with that is that, for example, in family court, there are no fees. But if you go to Supreme Court, there are very hefty fees. There are different court personnel. There are different court procedures. Individuals now who work may have to take off additional days because now they have court appearances in family court as well as court appearances in Supreme Court. The IDV courts, for example, were supposed to be a solution to try to really provide one forum for victims of domestic violence who also had either criminal cases or matrimonial cases involved. And it's had some success, and it depends from county to county. The family court cannot transfer any cases to the IDV courts. They select which cases they accept. And then, interestingly, even though the family court doesn't have jurisdiction over divorce matters, we have jurisdiction over all the post-divorce modifications and enforcements, which is an interesting thing because now the family court judge knows nothing about this divorce, did not preside over the divorce and all the complexities that went into crafting a very difficult, perhaps a very complicated divorce order. But now it comes to family court, let's say a year later for modification. The family court judge knows nothing about this family. So essentially, we have a real duplication of services and a real, the family court judge now has to start all over and, have a really extensive hearing in order to really understand the dynamics of this family and what is happening. We also get a lot of post-divorce modifications for child support, which is a huge area. Child support, family court right now in New York City is comprised of 5 family courts, 1 in each borough. We, on average, last year we had over 215,000 filings. And 40% of our filings are in the child support area. And another 40% are our custody visitation family offense area. So we have huge volume, but we also have some volume from both any supplementals filed in an IDV court will come back to family court, and many post modifications of divorce actions, as well as enforcement actions following matrimonial court, come back to family court. So while there was apparently, from all the things that I've read, there was a lot of concern about giving family court divorce jurisdiction. Primarily, from what I read and I see, is somewhat related to the sense that family court, because it was historically the children's court and historically the domestic relations court, that somehow we were not able or are able to handle really litigious cases or
Too kind and gentle, is it?
or yeah, the rules of evidence apply in family court, everyone. Heartily. We have extensive motion practice in family court. We do hugely, highly contested hearings in family court. So this myth that somehow family court is not equipped or the family court bench is not equipped is a complete myth. I mean, I don't know what else to say about that.
Let me just switch gears for 1 second. We have another anachronism. 80 years ago, the 1938 Constitutional Convention created population-based caps on our Supreme Court judges. But then we have a case, is it Taylor v. Seiss, that says you can move by order of the chief judge or the chief administrative judge, a judge anywhere. Why doesn't that solve the problem?
First of all, I think that the ratio that limits the number of Supreme Court justices actually originated, it may even have gone back as far as the 1894 convention, Constitution. Why doesn't it work? Well, I think in many respects it does. For example, in the city of New York, and this may be one of the reasons why court consolidation has been so elusive over the years, because we're really good at improvising under the present Constitution, and one of the improvisations is the use of Section 26 of Article 6, which is the section that authorizes the temporary assignment of judges. In New York City, there's something on the order of 300 or so Supreme Court parts operating daily in the city. Of that number, just under, maybe a little bit more than just under 1/2 of the judges who sit in those parts are Supreme Court justices who are elected from judicial districts, which is what the Constitution stipulates. But the remainder, more than 1/2 of the judges who are sitting, are dragooned in from the Court of Claims, from the civil court, from the criminal court, occasionally from the family court. So we actually do make it work. We have what I think is, we may have some difficulty outside the city where we do the same kind of thing, because there are legislators who themselves very much against the idea of court merger as a constitutional proposition, likewise feel uncomfortable with it as an administrative proposition. And so they watch over our shoulders fairly carefully to see just how often we're assigning judges as actings to the Supreme Court. I've felt this often. Taylor v. Seiss, you mentioned that. 33 New York 2nd, 354. I had to memorize that because I worked with Bob Seiss, and that was one of the requirements of the office. Anyway, that was a case. It was decided in 1974 by the Court of Appeals. It followed on the heels of the Rockefeller drug law, and this was the first big use. Judge Shankman mentioned the considerable use of Court of Claims judges as acting Supreme Court justices. Well, that pretty much originated in 1973-74. The Rockefeller drug laws were enacted, and in anticipation of a large increase in the narcotics caseload, and recognizing that the Constitution had this limitation on the number of Supreme Court justices who could be positions that could be created for New York City, the legislature said, all right, well, what we'll do is we'll create a whole bunch of Court of Claims judges, and then the administrative authorities in the court system will assign them temporarily to Supreme Court so that they can attend to this increase in the caseload. Well, a year or so later, a fellow by the name of John Taylor, who was convicted in front of Bob Seiss, Judge Seiss, who was a Court of Claims judge, one of the Rockefeller drug judges, sitting by assignment in Supreme Court, I think in the Bronx. He challenged that. He challenged, this guy's not a Supreme Court justice. And the Court of Appeals ruled that, no, Mr. Taylor, I'm sorry, nice try, but the Constitution very clearly says that a Court of Claims judge may be assigned to Supreme Court. And what's further, there really is no limitation, or at least we're going to leave the duration of this so-called temporary assignment, and that's the terminology in the Constitution, we're going to leave that to the decision of the assigning authority. At the time, it was the appellate division. Now it's the chief administrative judge. So we're not going to look behind an assignment. And so now here we are, 40 years later, and we have people who are temporary Court of Claims judges and others who are temporarily assigned to Supreme Court for decades. Mm-hmm. And I've often wondered whether or not, why somebody doesn't seek to challenge in the Court of Appeals, challenge that Taylor determination. At the time it was handed down, it made some sense. The state didn't have that much familiarity with the temporary assignment process. It was all pretty new, and they were talking about a year-long assignment anyway. But now we have these tremendously long assignments, And what if a case went to the Court of Appeals? What does that word temporary not mean something in Section 26?
Well, Judge Ruiz is shuddering. She's sitting here saying about a quarter of her judges in family court or civil court judges that have just been elected and sent to family court. Let me pick out another piece of history. 1894, our Constitution divides the state into 4 departments. Think about how differently situated we were. How many people were commuting from Suffolk into Manhattan? How many people were commuting from New City into Manhattan? That led to the busiest appellate court in the world, the 2nd Department. I know, Carrie, you proposed a 5th Department. What are the rationales there? Why didn't it take off?
It's really the same problem we were just talking about, but at the appellate level, which is that it's all frozen in time based upon demographics from 100 years ago, which no one anticipated what the world would look like today. And I think, again, the solution that that successive bodies have proposed and ruminated about for decades now has always been fairly obvious, which is the creation of yet another department. Yes, with all due credit to OCA's ability to make do and shuffle things around and create temporary assignments and move people, after a point you run up against simple geography. And if you look at the geography, I don't know if you have this slide, but of the different departments, and especially the 2nd Department, there's only so much you could do to move people across these jurisdictional boundaries, and have them commute day by day from Suffolk to Westchester or wherever, et cetera. And so, and you can carve it up, in a variety of different proposed ways, or one could, in the Constitution, leave it to the legislature, which is what our group recommended 10 years ago. But the, again, sort of simple, obvious solution is to create, yet another sort of demographically justified, department to, to make the numbers work and create a rational basis to allocate cases around the state. Again, you can do that in a variety of ways. We don't need to go into the details now, but to us, looking at this 10 years ago and looking back over what people had proposed in the past, it was, again, to use my prior words, just damn obvious.
So at the last convention, other than lawyers, probably the 2nd most populous were judges. The Constitution says judges shall not be disqualified from serving in a convention. What do you think that means if there's another convention, Judge Sheckman? Are we going to have as many judges as we have lawyers?
Well, actually, the Constitution has some very interesting things to say about it. It doesn't say all judges are disqualified from holding dual offices. It just says some, like on the judges of the Court of Appeals, Supreme Court judges, and judges from the New York City courts. Theoretically, a city court judge from outside the city, even if he or she was sitting full-time, could hold another public office. But for the fact that the canons of judicial ethics say that if you want to hold another elective, non-judicial office, you have to resign. So that's what prevents that. The provision for being a delegate to a convention is actually an exception to the general rule that's in the Constitution. While there is an argument that can be made that that exception doesn't necessarily mean permission, the historical record is such that it'd be very hard, I think, to construe that otherwise, simply for no other reason. As was pointed out, the Chief Judge of the Court of Appeals in 1938 was the chair of the convention. Very hard to argue then with a straight face, wait a minute, he shouldn't have been a delegate at all. That's simply wrong. This is might not have been such a big problem in 1967 if you think that that was a fairly limited duration convention. It's a different era. And frankly, the canon of codes of judicial ethics didn't exist. They came into being in New York as a result of the 1970s constitutional amendments that gave the chief administrative judge the authority to promulgate codes of ethics, which say, among other things, you can't speak out on a whole range of topics.
Or misbehave.
Or misbehave, or call people, and and there's been judicial conduct opinions, call people offensive names. Can't do that and still be a judge. So so it's theoretically possible that people may try to run. It's theoretically possible that people may try to say, I'd like to run and collect both salaries. But this creates all sorts of public difficulties, which is, well, what do you do with your day job? An example might be, suppose I woke up one morning and I said, you know what, I would really like to take a year off from being a judge. And maybe
Your
what I'd
boss
like...
is here, so that's what you
like
say.
to go, I'd like to go maybe teach at a law school. Suppose I get paid, suppose I don't get paid. Can I do that? What if I just walked away and said, you know what, I'll come back next year. I need to recharge my batteries. Could I do that? Suppose it's for something that we consider laudable. Suppose I got a leave of absence. Would that make it permissible? Could we do that? Could one get a leave of absence or be required to get a leave of absence to serve as a delegate? If this was treated potentially on an equal basis without discriminating between who wants to be a delegate, who wants to go teach in a law school, who needs 6 months to go rethink things, maybe there is a basis for some form of adjustment. One of the great ironies is when you do study the history of the 1967 convention, the judges who were there certainly wanted to keep the system that they had. The surrogates, I think it's fair to say, preferred keeping the surrogates court. The Supreme Court judges preferred keeping the Supreme Court. But when you listen to what the court system has to do, well, we can move somebody here to there on an acting basis. The fear that so many judges express about, well, I don't want to have a unified court because they could take me one day and move me from criminal to civil, or civil to criminal, or move me from tort to matrimonial to family, that actually happens to a great degree. And that by trying to resist a greater reform, we've actually built a world that they really probably shouldn't like very much. And I would add, just listening to this, that so much of our court system is based on what are now horrible anachronisms. Think about it. The family court has this horrible reputation because, it's not a real court. Well, there's a reason for that. When it was created in 1962 out of an amalgam of other courts, the thought was, let's do right by the kids and families. Law had nothing to do with it, except that in about 1965, the Supreme Court decided a little case by the name of In re Gale, which said that, yes, children have constitutional rights too. And that shifted the family court from whatever thought there had been that it was simply going to be a court of social justice into a court of law. Think about divorce. In the old days, almost all divorces were contested, and there was a right to a jury trial. Now we have a modern no-fault divorce statute, so almost no cases are going to be fought on the issue of divorce. Theoretically, we could assign or refer the support, custody, and certain other aspects of a Supreme Court divorce case to family court. That happens in places. What we're really talking about here, and that's why I disagree to a certain extent with Mark about, does the system really work? At the end of the day, unless you have enough judges, somebody's going to get shortchanged.
That's right.
What I think about when I think about the balance between, for example, Supreme Court and family court, well, what is it that we need the family court judges to do that the Supreme Court judges can't do? Why should we encourage people to bring cases in Supreme Court that maybe ought to be heard in family, and vice versa? Where do we draw that balance? How do we decide how many judges we need in each place? That's really the day-to-day issue, and there's nothing in the Constitution that addresses how one goes about that and how we prevent people and justice from being shortchanged.
So let's jump to the final thought here. We have a very patient audience, so we could be going at this until well past midnight, and I know you're not willing to do that. But, I mean, there's one issue alone in that this is one of the most anachronistic documents. We have a Constitution that calls for 11 judicial districts, yet we have 13. There's a constitution that now has this Commission on Judicial Conduct, yet it still talks about a court for trial of impeachments. There's a lot that could be cleaned up. None of us would draw out a court system that looks like this if we were doing it from scratch. But I'm going to each give you one sentence. What is the one most important thing that you would change that lawyers should care about? And I'll start with you, Judge Ruiz.
Thank you for that question. For me, as a manager, I manage a very large, voluminous court. And so my prism of my everyday is how do I serve all the litigants who come to our court with what is a relatively small judicial bench. So to me, it's the allocation of resources and the efficiency of how we manage our court system. Because ultimately, the people of the state of New York deserve no less, I think, from us, that we can really have an equitable court system with proper allocation of resources across all of the courts. And whether court merger is the way to do that, sounds to me like probably a good idea, but that's just my personal opinion. And of course, it's based on, what I see day to day in the family court and just the important nature of what we do in our court is just so important and valuable to the future. Now we have raised the age, so we know we're going to have more cases in our court. And again, that legislation, I think, reflects also this dichotomy of, what cases should go to what court based on a host of issues.
It's a long sentence, but a good one. Mark, without taking away the ability to pay for your grandkids' college tuitions, what is the one thing in one sentence that you would change?
I would eliminate the cap on the creation of new Supreme Court justices. I think that court consolidation, while the most admirable of goals, is probably politically too elusive, but I think we can best serve our needs if we have adequate resources. Again, I think we do a pretty good job in the judiciary at making do with what we have, and sure, it would be great if we could knock those 16,000 words down to a mere 4,000 or something like that. And if we could unify the courts completely, all kinds of good things would come from that. But I think at the end of the day, that's too difficult to achieve. And in the short term, I would push for the added resources, which would also, one other thing, would keep faith with a constitutional provision that says that justices of the Supreme Court should be elected from judicial districts, which is often left out of the conversations that we have. I think that's a pretty vital thing to remember. So that's the one.
How about you, Kerry?
Well, it's unfair. I think Mark just identified 3 different things, of which the last one was going to be my provocative suggestion. If you're saying I had a magic wand and could pick anything, and it hasn't been on the agenda tonight, and it probably shouldn't be as a practical matter, if there's going to be any hope for change in a constitutional convention, I would say merit selection. I think that would change so much of the system and get rid of a lot of our woes. The rest would be footnotes after that.
And final word, Judge Shankman.
I would like to see New York have a truly unified court system, and that to have those words in the Constitution mean something. And I'd like to elaborate for 1 second, if I could. I know it's another sentence. So much of the sinew of the court system has been constructed around courts. So we have a system, computer system for Supreme Court. We have a computer system for family court. We have a computer system for city court. We don't have a computer system for courts. And sometimes when we try to put things together, it doesn't work because we don't have systems that cooperate. Let me give you, and I see him sitting in the audience, and I'll give you a great idea of a unified court system. It's my good friend John Sweeney, who's now in the Appellate Division, First Department. But I had the occasion as a young lawyer, and he was a younger judge, to appear before him in Putnam County. In Putnam County, they're one of the counties that are called triple hatters, where the county judge is also the county judge, the family court judge, the surrogate, and can be an acting Supreme Court judge. All of these problems didn't exist in Judge Sweeney's court, because if it was a surrogate matter, surrogate court is now in session. If it was a criminal court matter, county court is now in session. Supreme Court, now in session. And if you really think about it, wouldn't it be wonderful to have a court system, however you achieved it, where people could get justice in some sort of organized, unified way?
That's a great way to end. I'll just add one more thought. If we were in upstate New York, that's the Boston Spa Justice Court and Fire Department and Ambulance Squad. I'm sure people upstate would also care about their town and village courts. I want to thank the audience. I want to thank our distinguished group. Thank you very much.
Very good.
I'm not sure.